Very good evening to all of you, and thank you very much for joining me for the seventh episode of the National Entrepreneurship Development Program. And today we're going to talk about the intellectual property, how important intellectual property for your business development. And in today's world, where most of the startups have some sort of innovation, invention, certainly leads to some sort of intellectual property, right? It can be a patent, it can be a trademark, it can be a design patent, or eventually a trade secret, right? So in any of all of these intellectual properties, as a startup developer, as an entrepreneur, you need to know how to manage your intellectual property. Otherwise, you can simply lose your intellectual property and it goes out to the world and you have no control over your own intellectual property. But if you know it very well, you can protect it and convert it into commercial returns to your company to make profits coming into the company based on your intellectual properties. So to tell all of these things about intellectual property, we have invited Professor Richard Cahoon from Cornell University, USA. And after his talk, Ms. Amali Hettige will talk to you about intellectual property, particularly patent prior art search. So it will be very exciting session ahead of your time today.
Professor Richard Cahoon is a president of Bioproperty Strategy Group Incorporated, an international intellectual property management and technology commercialization consulting firm. And he is a professor adjunct of the Department of Global Development, Cornell University, New York, USA. And he was a former director of technology transfer at Cornell University for 20 years. And he managed many number of technologies and successfully negotiated hundreds of license agreement, research contracts, and many other contracts for Cornell. And he has 40 years of experience related to business management and administration. Furthermore, supervised over 35 professional and administrative staff, and he's an inventor holding a patent. And Professor Cahoon advises on RP technology transfer and commercialization policies and practices, and also expert advisor of the international IP license platform for vegetable breeding companies headquartered in Netherlands. And Professor Cahoon and Cornell have launched on an online Cornell University certificate course on invention and IP management. So Professor Cahoon completed a PhD from Cornell in natural resources and MS in bioprocessing from Montana State. And finally, Professor Cahoon received degrees in political science and history from the University of Utah with minors in biology, chemistry, and Spanish. So I would like to cordially invite Professor Cahoon to start this session. Over to you, sir. Thank you.
Thank you. Nice to be here, and happy to talk about a subject that I know pretty well. I've been doing it for, as you heard, for several decades. I'm passionate about this subject. I got interested in intellectual property as an inventor. I'm an inventor and hold a patent, U.S. patent, and was really interested in the whole idea of taking innovation and invention and turning it into reality. And so that's really my primary focus. Over the years, I've managed to get titles and awards and different sort of levels of career achievement. But really, all of this that I'm going to talk to you about is based on the fact that I found useful tools in intellectual property and have found them to be extremely important, and particularly for the entrepreneurs among us, And so let's get started. I only have an hour and time will fly. It usually does. I'm going to share my screen here, and I presume you can. And by the way, it's nice to kind of be back in Sri Lanka. I'm not really there, but I feel like with all of you here with me reminds me of the good times I've had in Sri Lanka. I started coming to Sri Lanka back about 7 years ago as an advisor and a leader of a program that I designed for the World Intellectual Property Organization, which involved intellectual property and the use of intellectual property as a set of tools for new technology commercialization, entrepreneurship, economic development. And that's where I first met some really nice Sri Lankan colleagues, including Rohan. Rohan, good to see you again.
Hi, very good to see you here.
Thanks. So there's a little bit about me. You already heard too much about me, but I will just say that you can see there that I hold a patent, now lapsed, but U.S. patent 5,616,493, a bioprocess engineering patent. So that was a big part of my life back in my early days, bioprocess engineering, and I invented and created and started a company. That's the other thing. I founded a company called Associated Biotechnologies, and I lived for 3 years the trials and tribulations, the ups and downs of starting a company. And you will hear me talk about starting a company, and I feel like I can speak somewhat authoritatively about it because I started my own. I proceeded to have some successes, but some real challenges, and ultimately the company failed. Investment was lost. I lost some time, but I gained an incredible education. And along the way, then, I have advised and participated in dozens of new technology startups and continue to do a lot of advising for startups. I always have. Seems like there's 3 or 4 always going around me in some way or another. So why are we talking about entrepreneurship and intellectual property? Well, the first thought that occurred to me was entrepreneurship is really all about creativity. Entrepreneurs are creating something where nothing existed before, particularly maybe a company, but more than that, they're taking an idea, an invention, a discovery, some kind of a new creation and turning it into some business reality, something that can be bought, sold, traded, and turn it into a sustainable platform. When I first started as an inventor, I realized I wanted to see my inventions turned into reality. And I realized that in order to do that, I was going to have to get money, for one thing, and money resource means resources. And I realized that inventions and discoveries need more than simply just a lot of dedication. You need a platform of some sort, and intellectual property provided that, but also the company. And that's what really drove me to start a company and to become an entrepreneur. Entrepreneurs initially, essentially all you've got is your creativity and your commitment to the realization of your creative vision. Most of the entrepreneurs I know, they have a vision, they have creativity. They then work really hard to see that vision come to reality. I consider entrepreneurs to be some of my favorite creatives. The term you may have heard of. These are individuals that create new things for themselves, their families, for their societies, for their villages and regions, etc. We think of artists that are creatives, they create new works of art. Inventors create new technologies, and entrepreneurs create new businesses, essentially. And they create something new where nothing existed before. And so I celebrate all you creatives, you entrepreneurs who are striving to create something new where nothing has existed. That's not easy. That's a huge task. And frankly, I think that entrepreneurs are the saviors of the world in the long run. Intellectual property, as I've learned over decades, is the creative's best friend. So intellectual property, it has a long history, different kinds of intellectual property, which we'll talk about. But intellectual property in general has this long, long history where societies and smart people and civic-minded people have realized that we have to give creatives some tools. We have to give them some rewards and some tools to be able for them to realize the realization of their dreams of creating something new. And that's an acknowledgement that it's really good for society. It's good for all of us if these creatives who are creating something new have the tools, have the ability, and the incentive to create these new enterprises and these new products, these new services, these inventions. The fact is, intellectual property and these different types, which we will talk about later, gives creatives control. It gives creatives control over their creations. It gives them control and gives them some power. When you have control, you have the ability to control its use. And you also, with intellectual property, create, because it's a property right, you can create an asset. And so it has very significant power to give the creator that kind of control that they need to be able to, number one, have some incentive, and number two, to be able to structure the use and ultimate disposition of their inventions, their new products and their new services and their companies. So in essence, the intellectual property regime, and intellectual property exists around the world, of course, in national laws, embodied in national laws of patent laws and trademark and copyright. And all this allows the creative to create a property right from their creative mind. So unlike real estate, for example, we know real estate is a property right in land and its fixtures, buildings, and fixtures on the land. You can't create new land. I mean, yeah, I suppose there's a volcano or two in the middle of the ocean in which we've seen a little tiny bit of land created. But for the most part, you cannot create new land. However, with intellectual property, it's a constant source of new property. And it's a beautiful thing that a creative person can take their creative invention, discovery, work of art, and their new company and create a property right. And the property right gives the owner of that property right the ability to control its use, its disposition. So intellectual property is a set of tools, the way I think about it. There's nothing particularly, I would say, I mean, I'm fascinated by intellectual property per se, but that's not really why I got into it, nor is it something that I think most of us get interested in. We're not interested in IP because it's a beautiful thing. We're interested in intellectual property because they're tools. They're tools that help us build new products, new services from our inventions, and to build our companies. So these tools allow you to protect and control the creative assets. Most of my experience is with invention and discovery, which are patentable. But I've been doing this long enough now that I think of all my IP tools and weave them all together to create a, let's call it a symphony of intellectual property to achieve the goals of the creative entrepreneur, creative inventor. Here's probably the biggest reason that we like intellectual property is because it incentivizes investment. Most entrepreneurs need to have some investment. Maybe that's their own investment. Most entrepreneurs need others to invest in their vision. And so with intellectual property, it gives the power through the property right to incentivize those who would put money in. Simply put, if you have an invention and it requires $1 million to realize it, if somebody has the potential to see a return on that investment, then there's some incentive for that investment. If there is no ability to recover that investment, it's very hard to incentivize investors. I have spent decades now designing and building business models around intellectual property, around patents, around trade secrets, around the intellectual trademarks, around the intellectual property that is created to protect the invention or the technology. And then we use those intellectual property tools as a beginning point to design a business model around it. And intellectual property, again, I've spent decades doing this, where it provides a foundation for creating different types of business partnerships and arrangements. Once you have intellectual property in your hands, then you can do some really interesting things. You can find investors for your company. You can enter into joint venture arrangements between a small company and a bigger company. You can do licensing, where you license others the right to use your intellectual property. All kinds of arrangements can be structured if you have that intellectual property tool. So let's talk about it a little bit more in general. Intellectual property converts intellectual creations into a property right. Simply put, that's what it does. And once you have that property right, you can do a lot of different things with it. That property right can be used to control the intellectual asset. And it was designed, intellectual property laws were designed, patent law comes from the 1500s, where people realized that that inventors and creators needed the ability to control their invention. Otherwise, if they didn't have the ability to control their own invention or to own it, then there was no incentive for inventors to invent or creators to create. And so we have to give them the ability to stop others from simply reaching in and going, thank you very much, I'll take that now, and not pay a nickel. And there's no incentive for the inventor to invent. So it protects inventors and creators from theft and freeloading. I'm here to tell you, and you guys probably know this, that there are a lot of people out there who could care less about you and would simply take your invention and never think twice about it. And that we need the law and property rights to protect the interests of the inventor and the creator. Okay, so what it does is it creates a system in which we can put a boundary around our inventions and require that others will respect that. They can't trespass on our property without our authorization, and therefore that opens up the potential for transactions, to be able to sell our invention through our intellectual property, or to license it in some way, to turn it into, as we say, monetize it, to provide then a compensation and reward to the inventor. And this idea that inventors and creators deserve some reward is something now that is just woven into it's basically human nature, but it's woven through the particularly the patent laws in countries around the world. We've all realized that we need to do this for inventors if we want to see inventors incentivized to continue inventing. Intellectual property is an asset. It's like a property right that you would think of with real estate or personal property like your laptop and your car. These are assets. These are property assets, and just like those property assets of real estate, like your home property or an apartment building, they can be bought, sold. You can give them as gift. They can be traded, and that's really where I started to fall in love with intellectual property, because it gave me the ability as an inventor to use my property right as a tool for entering into business kinds of transactions. As I said earlier, one of the primary reasons we're interested in intellectual property is to incentivize investment. So if we are an entrepreneur and and an inventor and we need money, we want to incentivize investors to invest in us. And if we have a patent, then we have a way to do that. But in order for us to do these things, intellectual property has to be created, managed, and enforced. Okay, so it doesn't just happen. Okay, so a fundamental purpose of intellectual property is to develop and commercialize new technology, new companies, new products and services. That's really its fundamental purpose, and to protect those who do create new technology, new companies, products, and services. The intellectual property tools gives the entrepreneur control over business concept in various ways, and incentivizes investment of their own time and money, so that you can be protected, so somebody can't just easily take it away from you. Once you've invested time and effort and it's successful, somebody swoops in and simply takes your good idea, your good invention. As I said, you can build a business concept around your IP, around your patent, your trade secret, your trademark, your copyrights. And this is the way I normally counsel entrepreneurs, is you start with the basics. For the most part, those of us who have inventions, we have to think about what the proper intellectual property tools are, and then we apply them. And then from that, we can then begin to design our business concept or business model. We'll talk a little bit about business models. So they're going to protect these IP assets, and tools are all designed to protect the interests of the entrepreneur. So a little bit more in detail of what is IP, why it's important, why we should manage it. It's probably obvious, but I'm going to state it clearly, and how we manage intellectual property. First of all, what is it? Some of you may know what it is, and I wasn't quite sure who in the audience had any experience with IP. It's an intangible property right, as opposed to personal property or real estate. It's intangible, like money or stock certificates. It's a right that is granted through national law primarily. National patent laws, for example, you have them in Sri Lanka. We have them in the United States, and the patent laws of Sri Lanka cover Sri Lanka and only Sri Lanka, and the patent laws of the United States cover only the United States. So a U.S. patent has no power in Sri Lanka, and vice versa. Each of these tools, these different tools, which we'll talk about, protects creative works in a different way. And I started out thinking only about patents, the intellectual property. To me, intellectual property was synonymous with patents and vice versa. And gradually over time, as you become more and more exposed to different kinds of intellectual property and different situations, you realize that intellectual property is a set of different kinds of tools. Like when you build a house, you need a hammer, but you also need a screwdriver and a saw and a drill. And so to build a beautiful structure of a new company and a new a new product based on invention, you need different kinds of tools, and each will protect the creation or invention in a different way. They are different types for different purposes, and you can see there these are the primary intellectual property tools, patents, and of patents there are several. Utility, what we call the petty patent, or some people they're different names in different countries. Not all countries have them. I don't think Sri Lanka has a petty patent. Some countries, Philippines comes immediately to mind because I've got a client right now that I'm advising, and they call them utility models. They're like patents, but they're kind of reduced in scope and duration. And of different patents, there are different kinds. There are design patents, which cover the way things look, and the utility patent is the patent that covers methods and devices. And then there are plant patents. For those of you who are involved in plant technology and plant breeding or in agriculture, plant patents can become hugely valuable. I was just in an expert in a big litigation, $1 billion litigation that involved table grapes and plant patents. Trade secrets, these are really important for many situations. We usually mention Coca-Cola at this point because Coca-Cola is still a well-kept and managed trade secret that is worth billions of dollars, and it has been maintained as a secret for 100+ years. Of course, also combined with a trademark, and that's one of the other themes that I wanted to make you aware of in our discussion today, and that is that, in my experience, when you have a good technology, when you have a good invention, they're usually best protected by a suite or some bundle of different IP types. So in the case of Coca-Cola, we're talking about a trade secret. There's no patents on anything that regarding the beverage and its packaging. No patents anymore. There may have been at some time, but now it's all trade secret and trademark. Obviously, the Coca-Cola trademark is also very valuable. So trademarks, over time, I've realized the importance of combining patents, trademarks, and trade secrets. Also, we're not going to talk about certification marks. They're similar to trademarks. And then there's geographical indication where, for example, agricultural products grown in, like, gosh, I wouldn't be surprised that Ceylon cinnamon might be a GI. I'm not sure about that, but that it's a way for growers in a certain region to protect their produce that's unique to their region. And then copyrights. Copyrights play a bigger role in some areas than others. Copyrights are useful intellectual property in software, but also in anytime we're creating anything written or data formats. There are a lot of reasons why copyrights are almost always part of the mix. So a little more detail, and I won't go into this too much, but I'll just say patents, we have the key attributes are they're novel, inventive, they're useful, they are public documents. Inventiveness, and just keep in mind that a patent, an invention to be patentable has to be inventive. And that means it has to be unique, and that uniqueness confers some kind of superiority or advantage over existing technology. But remember, they're public documents. Copyrights protect the rights in the expression, the book, or in the software medium that it's reproduced in. But it doesn't protect the idea like a patent does. You can take ideas in a book and you can reproduce the ideas, but if there's a copyright on the book, you can't reproduce the book. Trademark, geographical indication, certification marks, they're normally rights in a word or two, a phrase or a single word. There's often a logo, some kind of a design. and then combinations of logo and design, the word and the design. There are trade secrets, as I mentioned. They are not registered. They're not public. They last forever as long as the secret lasts forever. They are limited in that if somebody can find the trade secret on their own legally, the trade secret owner cannot stop them. It requires management protection. I think it's almost always something to consider. Many inventions that I look at are both patentable but have a trade secret component to them. Utility models, as I said, they're or petty patents. They're similar to patents. They're not as powerful. They're shorter duration. There's plant breeders' rights. They're like patents, but they have some key differences. Then there's design patents. Design patents are patents on the way an object looks. Okay, so for example, I use the example of a shoe sole. You'll see shoe manufacturers will get a patent on the design of their sole, the special tread. Also true of automobile tires. You can't get a patent anymore on a shoe sole, but you can get it on the particular design. So why is it important to manage IP? Well, because without it, there's not much for those of us who want to build a startup. If you don't manage it, then you're not going to have IP, is the bottom line. It gives you that property right. You need to manage it in order to create that property right. And if managed properly, it creates value, which can be bought, sold, leased, traded. It doesn't matter how good your invention is in terms of its performance. If you don't have an intellectual property right, it's going to be exceedingly difficult for you to create value from that invention and to get the share of that value that you deserve. As I alluded to earlier, it's oftentimes the entrepreneur's only asset other than their own creativity and hard work and good looks. A patent pending may be the entrepreneur's primary asset. I've seen entrepreneurs who were able to raise significant money from investors because they had a pending patent on a good invention. Why should we manage it? Well, to create, maintain, and obtain control over the asset and to generate the value requires management, a certain level of it. And it's not going to do it on its own. You need to put energy into the creation and maintaining of IP. And if you don't do it, no one's going to do it for you, most likely. And I'm talking to all of you entrepreneurs. It's really going to be up to you to take active steps to manage your IP. And Rohan mentioned this. IP can be costly, and it's so easy to spend too much money. And I'm sorry to say that I see that frequently with newcomers, people who haven't done this before. They spend their money in a way that's not very prudent, that's not very cost effective. And admittedly, this is something that may take some experience to get, but I'm going to tell you a little bit later that there are ways to avoid spending too much money. Having cost-effective, and I use that term very carefully, cost-effective IP. And I believe we all, especially entrepreneurs, need to be thinking about cost-effectiveness. It takes thought, planning, and some attention to detail and follow through. Now, you notice I didn't say that it necessarily requires expertise. Would be great if you had 40 plus years of experience like me, but that's unlikely. So what can you do? Well, you can think about it, and today's lecture is a good start. Then you can start planning, and you've got to have some attention to detail and some follow through. And I'll tell you a little bit more about some of my recommendations of what you can do going forward. How do you manage it? Well, first of all, you want to be aware. This is something you can all do. Be aware of the different IP types and what rights they provide, how to create and obtain them, how they're maintained and enforced. Now, some of this is going to be over your head. I appreciate that. But you can start by just reading. I mean, we all can look up on the internet, Wikipedia, what is a patent? What is a copyright? What is a trade secret? Make sure you have some basic familiarity with what these different IP tools are. And understand, again, read, you're going to have to learn in a hurry on your own how to create it and obtain them. And each one is a little different about how you create them, and then how they're maintained and enforced, and then how to use them in transactions. Now, I'm not going to suggest that you do this all by reading. I'm also going to suggest that you try to talk to people. Now, it's a good start that you joined for this lecture. So get you a start, but you're going to want to, if you have inventions, you're going to want to start doing your own homework, but then you're going to want to start talking to people who have been down this road before. You could talk to Rohan. Rohan now has probably as much experience with patents as I would say 95% more. He has more patent experience than 95% of anyone else in Sri Lanka. So he'd probably be a good person to talk to. And you want to ask around to find the people who are knowledgeable and will help you. Managing intellectual property for inventions, first of all, you want to make a list of your possible IP tools. Patentability, is it patentable? Do you have a trade secret possibility? What about trademark? Then I make a sub list of the feasible IP tools. Like, for example, trade secret, you want to think about whether or not there's some aspect of your invention which could be kept secret, and you could maintain that secret over time. Some inventions, no, they're not feasible. They need to be told to people. They're going to be out there in the public. You're going to make a list of the feasible IP tools, and then you're going to think about, and this is all I'm asking you as entrepreneurs to consider, cost effectiveness. Now, you're not experts, that's okay, but at least start thinking about it, and you can start to write these things down, and then you're going to gather more information, and I'll tell you a little bit more about what I suggest you do. So, further managing IP for inventions is the patent. What you want to do is you want to determine, primarily, you can see there, is it inventive? That's the key attribute. Is it inventive? That means is it unique? And to do that, you need to do a prior art search. That just means you go in and you use keywords about your invention, and you find the patents and technical literature that are as close as possible to see if your invention is in fact unique, and if that uniqueness confers some advantage. And if you don't have uniqueness, you don't have patentability. And if you have uniqueness, but you don't have some superiority with that uniqueness, you also don't have inventiveness or patentability. As I said, can the invention be kept as a trade secret? Sometimes they can, sometimes they can't. Just think about what it would take to keep it as a secret. Are there any copyright materials? Do you have manuals? Is it software in which you can have a copyright in the code? Can you create, do you have one, or can you create a unique trademark that would have some potential value? Basically, you also want to ask the question, what's my overall purpose? I have an invention. If you're an entrepreneur, you have an invention you're building a company around. That's your overall purpose. And then there are going to be sub purposes, objectives, like, well, in order to be successful with my company, I'm going to need to be able to manufacture and sell my product or service. Is that my primary goal? Most entrepreneurs, that's what our goal is to manufacture and sell. These days, when we have things like digital inventions, we're going to be not really manufacturing, but we're going to be establishing an app and then marketing it and then figuring out a way to monetize. Are we going to license our IP? As I said, intellectual property is an asset that you can do a lot of different things with. You can manufacture it and sell products covered by it yourself, or you can have others do it for you. You can license out the technology to others, certainly in other countries if you're not there. You can sell You can sell the patent, you can sell the trade secret, you can sell the IP. You can use it to get investors to invest in your company. For a lot of us in small companies, we want to be thinking about branding the company itself. So do we want to think about the unique name? Are we going to try to come up with a branding strategy for the company, in which case we're thinking about our name and our logo, but also trade dress, product look and feel. For some of you entrepreneurs, this may be really important, the product look and feel. You can get a design patent on the way a product looks, and that may be one of your key attributes that you want to take advantage of with your company and your technology. So intellectual property and entrepreneurship. First of all, the question I would ask, do you have an invention? Is it patentable? Do you have a trade secret component? Could you come up with a useful trademark? I like to tell the story of my colleagues at the University of Florida. They came up with an invention. One of their inventors came up with an invention to replace electrolytes lost during heavy physical exertion. So they got a patent on that formulation, but they also got a trademark on the formulation use, and the trademark's called Gatorade. If some of you may know about Gatorade, others may not, but Gatorade is still it's been around since the 70s now. The patent has long since expired. University of Florida still receives millions of dollars every year for the use of the trademark Gatorade. So that message just to tell you, if you have a good invention that you maybe could use a trademark with it, you may want to combine them, because the trademark can last a very long time and generate revenue for you for a very long time. As I said earlier, inventions, in my experience, are usually covered by a suite or a bundle or a symphony, whatever analogy you want to use, of different IP types. Okay. If you have a branding strategy for your company, you want to be clearly thinking about trademark and design patents. So entrepreneurship and developing a IP strategy. Do your homework. So study up on these different types of IP. I've told you the main ones. Know what types of IP would be useful for your startup and its new product or service. Then seek advice sooner than later. Now, who to talk to? Well, that's a good question. I'll give you some recommendations here in a second. And I'm sure Rohan and course organizers, talk to people who you think might be knowledgeable. Ask them for suggestions on who might be good to talk to. Okay, certainly patent agents and IP lawyers. I say patent agents first because they don't charge so much for just simple advice. They prosecute patents, and they can be really helpful, and they'll give you a little bit of usually free advice. IP lawyers may too. Some IP lawyers are more than happy to give you some preliminary advice, maybe pro bono, to give you a free. One of the things I always like to do with lawyers is offer to take them to lunch. And if they'll go to lunch, they'll give you an hour, you buy their lunch, and you get a lot of initial free advice. Most of the good patent lawyers I know will give you a certain amount of free advice right at the beginning. Okay, so veteran business people, I cannot overstate the importance of finding people who are experienced in business. Maybe they're not that experienced in the business you're in, but find people who've spent years in business, and they can give you lots of really good advice. Of course, people who are experienced in the business of which your startup, of which your invention is targeted for, that, of course, is going to be invaluable. So, and maybe some of you are going, well, I'm not sure they'll want to talk to me. Well, I think you'll find different. Always be aware of associates of colleagues. That is, if you talk to some colleagues, some people that you know, maybe they're classmates or colleagues, say, hey, I'm looking to find somebody who might have experience in certain kind of business that my invention is involved in. They will recommend someone, and you call that person, and that person may be the person, or they'll refer you to somebody else. And of course, friends of friends. So there's a process to get started here where you can begin to go out. This is one of the things I find that successful entrepreneurs are good at this. And entrepreneurs who struggle mightily oftentimes don't even get started by going out and finding people to talk to. Use the 3 phone call rule. And over the years, I've been amazed at how well this 3 phone call rule works. What is the 3 phone call rule? You get an idea either by talking to somebody, or you just come up with the idea yourself. And you go, I wonder if this person might be able to tell me about the business that my invention is in. You call that person, and that person says, oh, interesting. Yeah, no, I'm really not the person, but I'll tell you who might be. They give you the name, and you call that person. And you call that person, and that person says, oh, yeah, I used to do that, but I don't do that anymore. And I'm really not the guy. Oh, you know who you should talk to is so-and-so. You call that person, and you got it. 3 phone call rule. And it works over and over. Okay, so implement it. So I'm going to end up here in the last few minutes with what I call the hero's journey. You've heard of the hero's journey. Well, in this case, the entrepreneur is the hero, right? And I acknowledge all of you who are embarking or thinking of embarking on this hero's journey. It is difficult. You will face many challenges of many different types. My wife came up to me when I was an entrepreneur, and she said, I'm giving you a choice, me and our marriage or your company. And guess what? I chose her. I've been married for 43 years. So there are going to be times when it will get so difficult and so painful, and you're going to have to figure out now. I went on to success after that. So my company wasn't a success, but that's okay. I was, and I learned a lot, and I was able to turn that failure into future successes. So I don't want to scare you to make you think that, oh, maybe you might fail too, but that's a possibility, but don't worry about it. Don't have fear, be fearless, keep going, learn to enjoy the challenges. They will make you smarter, more resilient, resourceful. The best people I know as startup specialists and entrepreneurs are the ones who failed, or at least came close to a failure, because they are the ones that are smarter, they're more resilient, and they're more resourceful. So embrace the challenge, okay? Write your business plan, in your own mind, and write it down how you're going to go from where you are now to where you're going to be in terms of the overall business, but certainly your IP. Review it and revise it often. And ask knowledgeable people for friendly criticism, okay? Put it in people's hands and say, what's wrong with this? What am I missing? Okay? And always be ready to pivot your strategy. That's the beauty of being an entrepreneur, is you're ready, willing, and able to make quick changes. Like big companies, existing companies can't do that, but an entrepreneur can. The importance of the business model. Some of you may know about the business model. There's a book out there, it's been around now for a couple of decades, I think, Business Model Design, and by Osterwalder and Pigneux. There's a lot out there on business model, and your business model design becomes key to your success. And don't get into the lifeboat of your startup. Don't get in the lifeboat with just anybody. I call a lifeboat because sometimes you're out there all alone, and you wonder if you'll ever get to shore, and it gets difficult. And there are a lot of people who they are not part of the solution. They're part of your problem. If you let them get in as your partner, and I know because it happened to me, just be really careful about the people that you want to get in a partnership with you, because it will be difficult. You want to be able to rely upon people and have people who don't lose control and become crazy and dysfunctional. Here's one of my final comments. People want to help you. You are an entrepreneur, and I've heard story after story, and I lived this too. People want you to be successful. And if you ask them for help and advice, many people along the journey will help you. I've heard some really uplifting stories where entrepreneurs have talked about the source of their success wasn't their invention, wasn't their IP, wasn't their hard work. I mean, all of those were factors, but it was at key moments. They needed some help. They asked for some help, and they got it from advisors, people in the industry, people who would, without compensation, without anything other than the fact that they're good human beings, they wanted you to be successful. So do not hesitate to ask for help. Even when, with regard to the IP, you can ask people for advice and for help. So with that, I think that leaves us with about 10 minutes of Q&A. Is that right, Rohan?
Yes, that's right. And wonderful presentation. I can keep watching all day long, Teak. I really like the way you present it and right to the brains and hearts of people. I think the participants, you guys are really, really fortunate to be able to listen to Dr. Cahoon, one of the best people on this planet about intellectual property. I haven't seen anybody better explaining this subject. Matter of fact, he's one of my mentors. I always say that, and Richard has been a very good supporter, mentor, consultant for all of us in Sri Lanka for so many years now. And if not for Dr. Cahoon, we wouldn't have been in this position today in building our innovation ecosystem in Sri Lanka, particularly in the universities. So I thank you, Richard, for your wonderful presentation once again. I saw a couple of questions in the chat. Andrew is asking what would be the best stage in the process of invention to start the process to seek patent rights. I think he's not very clear at what point they need to be serious about this intellectual property protection.
So, good question. First of all, the one thing you want to make sure you never do is don't lose your patent rights by making a public disclosure or, writing it and making it public. You want to keep it to yourself. You want to keep it secret until you decide, whether or not you can file a patent, and then you want to consider it. First of all, you want to do an inventiveness analysis to determine whether or not you have inventiveness. Do a prior art search. And you can do your own. Use Google Patents to see whether or not you might have some preliminary thoughts on inventiveness. I would talk to a patent agent or a patent lawyer fairly soon. I mean, and whatever you do, don't disclose it. Don't make it public. And so you'll preserve your potential patent rights. But I would not wait too long. I would do some of my own homework and I would do my own prior art search. But I would probably want to be taking some action within I would say 2 or 3 months of if I've made an invention. And that's the other thing too. There's a distinction between ideas. We all have a lot of ideas all the time. But when is it coalesced into an invention? An invention really needs to be inventive. And inventive means it has to be, among other criteria, the primary one is that inventiveness that I told you about. So go do some homework, see if you've got inventiveness. And if you do, I would say write the thing down very thoroughly and then go talk to if you can find a patent agent, go talk to them as soon as you get some written down.
Right. I think, Andrew, you got your question answered. We have another question in the chat. He's asking Vigneswaran. Before that,
I see a question there. Can we get a patent on a concept?
Yeah, that's right.
I mean, so it depends upon what you mean by a concept. You can't get a patent on an idea. It needs to be inventive. For a concept or idea, whatever you want to call it, it has to be novel. In other words, it can't have been published anywhere. we have a 1-year grace period in certain countries like the US. So once, if you did publish it, you still have a year. But essentially, it has to be novel and it has to be useful, which is pretty low bar. Most patent offices don't really care that much about the level of functionality, but it's got to be inventive. So if the concept that you're thinking of is inventive, number one, it has some definable, you can define it, it's definable, and that then can be determined whether or not it's unique or not. And if it is, the question is, does that uniqueness confer some advantage? And patents are issued all the time on methods, processes, things. So it's pretty broad what you can patent. There's a hand raise. Do you want to state your question?
And also there's a similar question, say asking which ones are not eligible.
Which ones are not patentable?
Not patentable, yeah.
Well, that's also a very good question, and that's a very much a country by country issue. There are countries that are more restrictive than others. The U.S. is pretty liberal, but even in our patent law, you can't get a patent on things of nature, like just simple discoveries of nature. You can't get a patent on an algorithm or mathematical formula. In some countries, you can't get patents on things like microbes. In the US, you can get a patent on an identified microorganism. But in other countries, not sure about Sri Lanka, but many countries, or you can't get a patent on plants, on a new plant breed. So you have to go in. This is where you could probably look it up in the law in Sri Lanka to see what's patentable, what isn't. But generally speaking, mathematical equations and things that are of nature. I know that's kind of a loaded term, isn't it? But you should talk to a patent lawyer or a patent agent to find out whether or not your invention is patentable subject matter.
Great. Excellent.
And there's a hand raise there from Vineswaran.
Hi, Professor.
Hi.
Is it possible to know whether we need to register the IP in particular country or in one country internationally that will applicable to other countries as well?
Good question. So when we start thinking about, for patents are, strictly speaking, they're country by country. And to get a patent, a valid patent in Sri Lanka, you need to file in Sri Lanka, and the same in every other country. However, there is a mechanism by which you can get you can essentially file a patent application that has potential to be filed in most countries of the world, and that's called the PCT, or Patent Cooperation Treaty. And the PCT, every country that is a member, if you file, and I believe Sri Lanka is, you can file within 1 year. You can say you file in Sri Lanka, within 1 year you filed a PCT application, which is administered by the World Intellectual Property Organization, and then you have a potential patent application that can be filed in other countries. So, for example, and then you have about a 30-month period to decide. For example, if you want to go into the United States, then you can file a separate U.S. patent. But this PCT gives you essentially a pending patent position around the world once you file initially in some country.
Excellent. I think we had a very good session with Dr. Colquhoun. And if you have any follow-up questions, please email to the common email address for the course. I will compile them in one document and send it to Professor Colquhoun. He will probably provide me simple answers so that I can distribute it to all of you guys. Thank you very much, Dr. Colquhoun, for sharing your time with us. We really appreciate it.
Thank you, Rohan.
And
My pleasure. And good luck to everybody, all of you entrepreneurs and will be entrepreneurs and supporters of entrepreneurs.
excellent. And I remember
Bye-bye.
one day, Richard talked to me when I was at Cornell. We were talking about various things on frequent basis. And I remember Richard was saying one day, okay, if I have to select people on my lifeboat, and you will be one of them. I still remember
That's
that.
true.
Lifeboat.
That's
Yeah.
true. Rohan, you are invited to my lifeboat, and I hope you can invite me too. Thanks.
Yep,
Thanks, everybody.
definitely. Thanks, and
Bye-bye.
have a good day, Dick. I'll see you soon. Bye-bye. All right. So that was a wonderful blast. And this is very interesting to be able to hear uh, to these people who have been living in this domain for so many years, decades, and collecting a lot of information outside our domain. Sri Lanka is a very, very small country, and we don't get to that kind of experience and scale and all that. Usually in the US, the patent thing is a very, very big thing, right? And if you look at the value of the patents in millions and billions of dollars, you look at the Gatorade trademark, not even a patent, it's just a trademark, but how much money the University of Florida is getting every year. And this invention is like 50 years old now, right? So this is the power of having a good patent, good trademark, or any intellectual property. If you have properly secured it, right, it'll keep coming, right, getting you return of investment for decades and decades and decades. But still in Sri Lanka, we have to gear this up. It is not fully mechanized to the system. And some people have a lot of different ideas, myths about patents, and some people, even very higher up people in this country, with a lack of knowledge about these things, not going through proper education about what is intellectual property, they simply say, no, we don't want patents, we just want to disclose our knowledge, whatever invention, right, for everybody. That's fine. But if somebody takes it and doing business commercially, deploy that patent based entirely on your invention, that's not right. Okay, you are supposed to get some share of that invention. All right, and particularly if the invention goes out of this country to some other country, and there are people who are making a lot of money out of that, commercially deployed this invention, those are not good, right? So that is why it is important to protect your intellectual property. All right, so now it's time to introduce our next speaker today. Pratibha.
Yes, sir. Here, Mrs. Amal Hettiges, a manager at the University Business League, with over 4 years of experience in intellectual property management, licensing, negotiation, and technology transfer. In addition, she has over 9 years of experience in treatment plant operations, quality assurance, and sustainability management. And she managed the quality assurance team and led sustainability-related projects. And she is a leader auditor and internal auditor for particular ISO standards. And she completed IP-related courses prior at Searchers, Parent Drafting, IP Management, WIPO, Professional Development Certification in Management and Commercialization of IP Assets, and an IP study course at the Osaka Institute of Technology in Japan, etc. And Mrs. Amadi completed BSc in Molecular Biology and Biotechnology from the University of Peradeniya, as well as her master in Natural Resources Management. And I would like to cordially invite Mrs. Amali Hettige to continue this session. Over to you, madam.
Thank you, Pratibha. I think nice to see you all again, because yesterday also we had a little session, but so I would like to continue the session. Can you please give me the access for sharing?
I think you can share your screen. Try it.
Okay. So basically, I think you can visible, no? My screen's visible.
Yeah, all good.
Okay, so sure. So I think where we stop is related to the how to do a prior search. Basically, these are the main steps to do a prior search. I believe you remembered from yesterday's session what is a prior. So basically, anything disclosed before your filing date, the examiners consider as a prior. This is publicly available ones. So for that, what you have to do is first, before you do start your prior search, you can describe your invention. I think Professor Kahun also mentioned this one. You have to describe your invention. You have to write it clearly. So this is a simple example I taken to go through this prior search pathway. So basically, you have to explain what does it do, what is the end product, and what is it made of. Like that, you have to describe your invention. Then you can conduct a simple keyword search. So during this keyword search, what you can do is you can use synonyms, even similar properties, the booleans, wildcard. There are different type of things you can use during this keyword search. And then after that, you can confirm by yourself whether you are in a correct way of doing this prior search. For that, you have to just select the some of the priors or the identified patterns or not patterns, and then go through them deeply. What is its background, what is the summary, and the detailed description. And also there is another way of doing that is the classification search. And also you can do the cited document searches as well. And then finally, most importantly, please don't do prior using only one search databases. You can use more than one search engine for that. So basically, for the prior searches, this is just a theory, but I know because normally when we are doing in the university, this is 1.5 hour lecture. So I'll just try to go through and I'll try my best to explain you as much as possible within this given time. Okay. So basically, when I said about after you describe your invention, what you have to do is you can do a keyword search. So basically, when you are doing this keyword search, I said these are some of the things. For an example, if you are double quoted a word, for an example, it is an electric car. You can make sure when you are sure that you want to definitely find priors based on this electric car, and both words must be in the same location. You can add double quotes for that. So other than that, even for one word, for an example, in US and UK, for the same words, even for the same meaning, they are using different words. For an example, someone talk at sidewalks and others take at pavements, something like that. As well as a strategy when we are writing our patent drafts, for the same item, different patent examiner, the attorneys will write in different way. Even the inventors may write in a different way. So make sure to find the synonyms for the word what you are mostly familiar with, and use all these the much as possible, use those synonyms as well during your searches. And there's another option called wildcard. So this is an example for that. That means if you have the word elect and a star, so anything after elect, electric, electrical, electronic, the words anything after coming after electric will be displayed in your search. So by that, it is helpful to use it to not missing any important patent, the important clause prior to your invention. That is the main reason why we are normally applying this type of technologies when we are doing our prior search. And then also we all know we can do Boolean operators. We can add Boolean operators as well. And also we can do grouping as well. I know though explaining this by words, it's very difficult. You have to do by your prior search, then you can understand it very clearly to where you have to add these kind of Booleans or grouping or these kind of techniques as well. So these are some of the Boolean operators as well. because I just included these things because I shared this presentation with you all. Next is, I told you the next one is patent classification. So basically there are two types of patent classifications are there. One is international patent classification. The other one is cooperative patent classification. So this is the website of the international patent classification. It is maintained by World Intellectual Property Organization, and you have to just click this access to IPC publication. This is how you can see it. So there are mainly 8 section titles in each of these one. So you need to identify what is the best classification or the best title where your invention belongs to. It is very important and it can narrow down your prior search. Otherwise, if you are just typing your title of your invention, there may be few thousands or even few millions of data can be identified by the search engine. But you need to narrow down what are the most closest prior, and then after that you have to review those prior to identify what are the similarities, what are the differences, and what are the actual novel parts and the non-obvious parts of your invention. Maybe your full invention can be novel, or maybe some parts of the invention can be novel. So based on that only, you can write your draft in a better way without, again, otherwise the examiners will be identified there are some features are not novel and they will reject the patent and you have to argue it again back. That's why normally it is important to do even a simple prior before you draft your patent and applying a patent. Okay. So the second one is cooperative patent classification. This is a jointly developed product by European Patent Office and USPTO. So they are, other than 8 main titles, there are an extra title as well. So from that also you can do the patent classification. Basically in Sri Lanka as well as most of the countries, they use both of these or either one of these patent classification for their searches, especially the patent examiners. That's why we also need to do the same. Then we can figure it out before they find it out. Okay. So I think Professor Kahun also told you that you can do the prior searches by using the available databases. So there are 2 types of databases. One type of database is publicly available. That means free databases. The other one is subscription databases. So you have to pay it. I think as entrepreneurs, it is better to start with the free databases because these are free. You can just Google it and get these are the websites. I just included those for your references. So PatentScope, SparseNet, USPTO, Lens, and so many, even many patent office sites also you can do the prior searches freely. Okay. And then the next one is the Google patent. This is the most easiest one. Though this is easy, it only have a few data because it is only covered. It is not covered many jurisdictions compared to the other available databases. But I think we all are more familiar with Google search. This is maybe easy for all of us. So you can just type it as Google patent search, and this is the site you can see, and you can see the results. So in here also, you can add some booleans and wording as told you before. This is one of the examples which I did. The next is PatentScope. So basically, as I told you, this PatentScope is managed by World Intellectual Property. Compared to the Google patent, this covered many jurisdictions compared to Google search, and also this database has more search options, just like advanced, simple, field combinations, and these kinds of things are there to do your search. So compared to the Google search, this is more relevant and you can get more results as well. But you need to train to do these kind of searches. Next is USPTO. So basically this is managed by United States Patent Office. So it is covered the patents and patent applications within US, but you can also freely do the searches using this database. So basically in USPTO, it is easy because all the things how you can do these searches are normally mentioned in their website. So videos are also available. You can go through and you can do your search by your own. Okay. Next is Sparsnet. So this is the database managed by European Patent Office. It also covered many jurisdictions compared to the other databases. It also have advanced and simple search options as well. And also, normally if it is in China or other languages, it has a mechanical translated information as well. So that is also really important. So this is how its website look like. And then I just add one example of portable water filter. That is where I started. So just if you type portable water filter, you can see this much of data is available. Results are available. Okay. So now I go through, because there are so many free databases. Today I plan just go through the Sparsnet database and so show how to reduce the number of prior searches, because otherwise it is, if this kind of number of searches are available, it is very difficult you to go through each of these and find whether your invention is novel and inventive. That is the reason. So if you are just type the portable water filter without anything, it is the search engine reading this as portable and water and filter. So anywhere in a patent, these words are there, your search engine will be find it out. So this kind of results will be available there. So now what we can here, you can see the same thing. Even though you write portable water filter or this way, the results are same. And then what you can do is, and what I did was I add some synonyms as well. For the same word, the filter, I add few synonyms. When we are at synonyms, as I said earlier, maybe for you, the same word, people in a patent draft, people use in a different way. You can see, then the number of patents or the number of results are increased compared to the earlier one. That is why it is important to have synonyms when it is needed, because it is not missed any important priors if so. Okay. And then the classification search. Then normally if you go through this one, here you can see just you can type the classification search in the Sparsnet search engine. Then this is how it look like in the website. And doing the classification search.
Professor, can you excuse? Hello?
Yeah. So we are currently doing the classification search. As I said, so basically there are two classification search. So because we are doing the search engine in Sparsnet, so we can have the CPC classification. So in that classification, what you have to do is we have to click this classification search and type your main title and do the search. And what you can see here is these are the results. And you can just go through these results and find the best option. And then you have to just click it and find patterns. And then the results will be appear. Okay, that is it. So this is then how it looks like. And then other than that, so then in the Sparsnet, there are more, other than the simple search, there are advanced searches and filters as well. So what you can do is you can reduce your number of results by adding these searches. For an example, in the advanced searches, you can add many fields and including so many booleans as well as boolean operators, and identify the field as well. And also you can include the filters as needed. So therefore, just what you have to do is you have to just click on these buttons, and these buttons are green, means they are active. and you can add these things and do your search. So when you are doing search like that, normally you can see your results is reduced drastically. But please make sure when you are reducing your results, you need to double check. Just click the more relevant. That means the relevance you can see the relevance part. In the relevance section, you can see, make sure to have the top relevance at the beginning and the others are at the end. So you can just browse one or two and find whether you are in the correct path of doing your search. So from that you can reduce your number of searches. And also in this, as I said you before, these are the fields available. So even that you can identify the fields as well. This is how I did it. So when I included the fields, because I think the gravel and sand must be in the claims part. And then you can see how the results are reduced. I know, though I said it like that, you have to do it by your own. You have to you have the hand practice as well to do this kind of things. But I think if you know something about this, at least you can start and you can get some data about your invention, at least to find whether your invention is new and not obvious as well. That's why I want to tell you. So and here I think when you are change the booleans, how the results can be changed here. When I add the boolean O, that means whether in the claims, the gravel or sand, then there will be more results, 97 results. And I'm sure in my invention, I use both. So except O, what I did was I add the boolean and. You see, then the results are reduced. But the 20 is a feasible amount to just go through each of the pattern and find whether these identified results are similar to your invention or not. And you can use this data as well. So that is how normally we are doing a prior search. But I have to repeat this again, though we also doing this many times and we are practicing this many times. I know Professor Rohan knows this very well. We did it many times again and again to get this kind of results. So you need to do this and you have to practice this as well. So other than that, I said you before, there is something called citations. So when you find a pattern and you can go for the citations, and then you may find out more similar patterns, because in the citations, they identify, the examiners identify what are the similar patterns to compare it into your ones, and they are included in that one. So in the citations also, important part to identify the similar patterns for your invention. Here you can see citations. And also other than that, there is, I said, if you are quoted your words, that is portable water filter, then the results are very low compared to the just to have portable water filter. But you have to make sure and you have to be very careful. Maybe this kind of thing, you may reduce your number of patterns, not because you identify the closest one, because you add the quoted cited. That's the reason. So therefore, when you are adding some kind of techniques, you have to be very careful, especially when you are doing your prior search. And then now I move to how to read a pattern and how to extract important information from a pattern. So basically, pattern document in anywhere in the world. I think the question is repeated again and again regarding this, whether there is something called international pattern. There is nothing called international pattern, but in all the patterns, basically these information are covered. One is bibliographic information, the second is technical information, and the third is legal information. So the bibliographic information is the basic information. What is the title, whether patent is grant or whether it is an application, what is the citations, and who are the inventors, who are the applicant. These information sometimes important for you. Just think that you need to know whether your invention where your invention is, where the market or where the leaders are. So in that case, you can find who are the applicant of your invention. From that, the bibliographic information, you can find that data. So this kind of basic information you can find from the bibliographic information. The second is technical information. Technical information is really important. So after, if this patent is collapsed or after 20 years of time, if someone need to rebuild this invention, you have to use this technical information compared to normal research papers or the news articles, anything. Within this technical information, so many detailed informations are available. So it is including the drawings, descriptive, the detailed description, all these are under this technical information. Then the third one is the most important one, that is the legal information. So claims go under this legal information. So mainly when a patent examiner is examined, they are first go through this legal information. That is, they are check for the claims to whether to find out whether your invention is novel. So these are the same things I explained you earlier. So I think because of the time, I don't want to go through this again and again. And also another important thing is international agreed number for a identification of data. That means normally in a patent document, if you see these numbers, though it is in a different language, number 11 is for patent number. And if you see number 51, that is for international patent classification. So by these numbers, it is universal. So basically by these numbers, what is important is maybe you may unable to read the language, but still you can identify what is in there. And these are the most, some of the things, some of the example I included. And normally in a patent document, you can see there's a number. For an example, normally B is for granted patent. A is for patent applications. So it's like that you can identify whether this is granted or not, whether it is only an application. These kind of data can be identified. And there are some data, as I explained you earlier, those are available. This is the front page of a US patent published data patent. And I think Professor Kuhn also told regarding that PCT. So in the PCT, how it looks like. This is normally when a PCT, this is the first page of when you are applying for a PCT. And you can see here in the PCT, normally in PCT, they are not granting a patent. It is the way you can apply patent not only within country, for the so many countries, you can apply using a single application. So, but you have to make sure after this, what they are giving is an international search report, not grant the patent. But this international grant search report can use to give you an understanding about your novelty and obviousness, inventiveness about your patent, as well as from that international search report and this data, you can apply patents in a national patent office. So how it is look like is like this. And this, I don't want to go through this again and again because of the timeline. I think, Professor Rohan, I don't believe we don't have that much time to go for the other one.
All right, Amali. Yeah, so? I understand. Yeah, thank you very much for that. And
yeah, sir, there's one more thing because they are I think most are very concerned about whether there is an international one. I just go through this one. I think this is important for the one who are interested with this one. As I said it before, there is nothing called international patent. There are two options basically. Either you have to directly apply for national patent offices, then one country will be covered. But that patent office will be decided whether they grant a patent or not. And also there are regional patent officers. From that, you can cover some or all of the member countries. That are the main two options. But as Professor Kohun said, you can file an international patent application. So, because we are covered under Paris Convention, we have a chance. This is how it looks like. here you can see, because we are doing, we are also under Paris Convention. Normally, we have a national treatment. That means, just think, today you are applying your patent in Sri Lanka. You have 12 months to applying your same invention in the countries which is covered by Paris Convention. That is one way. The another way is the PCT. That means you are applying your application within Sri Lanka, and within 12 months, you can do the PCT application. Then, because of the PCT application, again, you can have another 18 months to go for the national PACE application. Most important thing is, so with this period, you can find, because within this period, normally after 18 months, they will issue you, normally within 16 months, they will issue you international search report. Because of that, you can identify whether your invention is novel or not, or whether it is obvious or not. And also you have a time to identify the commercial partners, your company strategies as well. So this is that is the importance of to have a PCT. But I have to sad to say this, normally it is around 1 million. Yeah, it's around 1 million rupees in Sri Lankan rupees may cost for a PCT application. But still you have a very good case, and you are sure that you can go for a foreign market. More than 8 countries you can cover. Then PCT will be a good opportunity for you. So thank you. That's the things I just want to highlight.
Excellent. Yeah, I agree. This is important information for everybody. Participants, you will get the documents, PowerPoint and videos so that you can read and understand again, right? Amali, we have a couple of questions. If you don't mind, we can have quick answers.
Sure.
The first question is, how safe is it to input your innovative idea on web using search engines to check patterns when AI apps are collecting data? Is it safe, and what precautions can we take?
Normally, sir, though I believe everyone, even you are not in Sri Lanka or another countries, normally we are doing the searches with the guaranteed databases. So that is the only way you have to do a prior search. I believe that is the way normally in all the international, though you are applying a PCT, they are also use the same databases. Normally, that is the thing. So there is not another way of doing the prior search except that. So
Yeah,
I believe,
I agree.
that's the thing. But this is the first time I heard, but I never heard that kind of complaint from anyone. Because I can even search for, is there anything like that? But I know if there's that kind of significant case, definitely it will be in WIPO websites, USPTO websites. But up to now, I never heard that kind of news from anyone.
Yeah. So you do not use general search engines like Google, for example, and you don't write entire invention there, right? Your invention, you cannot explain it, right, in 1 or 2 words. Therefore, you do the search in the search databases like eSpaceNet, PatentScope, PatSnap, like that. Okay, specific databases. There also you use few keywords. You do not disclose your idea, right? Never disclose your entire idea on the web. Once you do that, it doesn't matter whether somebody is picking up or not, but you will not be able to patent yourself, your own idea. If you write it down and publish on your websites, Facebook, LinkedIn, or wherever, don't do that, right? The moment you do that, the patentability is gone. Your own document, your own Facebook, your own LinkedIn, and you explain everything and publish it, gone. Never think of patentability anymore. The moment you do that, your patentability void, right? So you cannot get the patent after that, right? If you have 1 year grace period like in US, that is a separate matter. But for most of the other countries, patentability is lost the moment you publish it. All right. So those are the questions. Trademark registration. Somebody's asking, what is the process
Yeah,
for trademark
yeah,
registration?
basically, I believe this is for Sri Lanka they are asking because
Yeah.
as I explained to you earlier as well, so IP is normally territorial. So it is definitely country to country, you have to identify their laws. So if you are talking about Sri Lanka, you can just, I'll show you the website. You can go to the website and see in the website normally they mention, so this is their website. Because I share these things, that's why I did it. So this is our website. So under these services, they have the services for trademarks as well. So just like patents, in those websites, there is an application, and also you make sure there are some criterias you need to fulfill if you are apply for a trademark. That means, for an example, an apple, for if you are selling apples, just fruit, then you can't apply the same trademark for an apple. But apple for a computer, yes, it's eligible like that. And also in the National Patent Office, before you are applying a trademark, you can go there and you can do the prior from there. They will tell you before you are apply, you have to just pay some nominal fee. I think it's the fair fee you have to pay. Then they will tell you before applying it, whether it is available, the mark is available in Sri Lanka or not. Then it is easy. Then what you have to do is you have to fill your application, because it's easy and it is also guided as well. And also with your trademark, you can do your application. So it also varies as well. For an example, if it is a logo and you need to have your colors and things, then you are sure that those are not changed, then you can mention those things in the application in a separate space even. But still you have a name only, and you are still not sure which color you want to take, whether you want to have some designs. Just in that case, you can register only your name for the safe side. So in that case, don't include any font or specified the fonts or colors. Then your name will be identified. Okay. So that is it. I know this is not enough for you, but I want to also tell you that all the universities now, all the state universities, they have the UBLC unit. So if you want to know anything, including University of Moratuwa, myself as well, we will help you to do that. Other than that, I believe NIA also will help. If you need anything more assistance, they will also help you, because I know this is maybe not enough for your for what you are asking. Just I want to tell you the basics. That's all. Sorry for that.
Yeah,
And
excellent, Amali. Yeah, so
there are one more, sir. It's okay. I'll go through that one as well.
yeah,
So
while you are finding it out, I want to reiterate what Amali just mentioned. Somebody asked earlier, right, whom to talk to. And Professor Cahoon, in his lecture, he also mentioned that you need to talk to professionals. Now, I want to reiterate this one. So it is not our intention or expectation that you would be experts in intellectual property, right? So even after this session, you take time to become an expert in intellectual property. That is not the expectation here. The expectation is that we want to make you smarter as in your entrepreneurial journey, right? So if you confine yourself to become an IP expert, you will lose sight of your entrepreneurial job, right? But now you know, having heard to these lectures, that this is a very important thing. So the best way is that you are the entrepreneur, you are the manager, right? You talk to individuals who are experts in different areas, including IP, right? So that you can save your time, right? And manage all the resources to your journey. That is the expectation, all right? That is the hallmark of a good, smart, competent entrepreneur. He's not going to do everything by himself. So never do that. Don't try to be an expert in any of these things yourself. It will not happen, right? And your entrepreneurial journey will be disturbed if you try to. So you can talk. Amali graciously volunteered, right? If you have any, you need to know a bit of everything, right? You need to know what is intellectual property, how to manage it, why it is important, and all these things. But you don't need to be an expert in that area. You can talk to Amali, and Amali will connect you to other UPL cells around the country, and she will connect you to another expert and all that. Remember, Dr. Kahun was telling you about 3 phone calls, right? If Amali is not the best person, she will connect you with someone else. And now let us know, let Vindhya know at NIA, if you need any support on intellectual property matters, we can connect you to best people so that you can save your time. Yes, Amali, please go ahead if you have anything. Yeah.
Yes, sir. There's one more question regarding the whether if a local patent application is made, therefore, which is the better method to get more coverage? It is under the Paris Convention or PCT application. So it's like this actually. If you are Sri Lanka, we are under the Paris Convention. So if you are applying a patent in Sri Lanka, you have within 12 months you can apply the same invention in the countries which is covered in the Paris Convention. There are so many countries covered under Paris Convention, but please make in your mind that it is a very critical decision because patents are very costly. So you have to pay the fees and you have to follow the application process and you have to do it like that. That is one way of doing that. The second way is the PCT. So PCT, the difference is normally within 12 months from today you are applying is within 12 months you applying for a PCT, then you will give another 18 months to apply for another national patents. That means National Patent Office in different countries. The advantage is you can get more months to decide which countries you have to do, what kind of strategies you have to do, whether you have to license your product, whether you can talk with some of the industry partners. But the thing is that though the PCT also bit of costly, actually, the truly speaking, that is also costly. So everything is basically on your strategies because IP management and also IP strategies working with the entrepreneurships are also special subjects because these are important based on what is your invention, how important your invention. Just like that what Kirti said in the yesterday session, because they know their one is very important and they know that it is new. So in that case, you can go for that level. But if you are not sure, that's why I said you have a general idea and you can do a basic search and find whether your one is truly novel and it can challenge what is available in the world. If so, and also it is easy to go for market by protecting the IP. In that case, you can have this decision. So basically, you all need to know because this is an entrepreneurship course. So normally we are not encouraging everyone just to have a patent, to sake of patent, just to have a patent. What you need to do is you have to identify what is the feasible way, what is the best way to what kind of patents you need. Either though patents is not needed, you need the trademark is enough. It is Sri Lanka also enough. That's why. So it is your decision. But for that, you need to have a bit understanding about the intellectual property. I believe my answer is you are clear with my answer.
Correct. So the last words is that you need to work with an expert because all these things Amali mentioned just now, you cannot decide. All right. No matter how hard you try, it's very difficult. So you need to talk to not one, maybe few experts in the area. That is how people do that. So let me share a few points here. Number one, how do you make sure that your invention is novel and inventive? It's by comparing your one with the others who have done that before. So therefore, you should not miss any of the relevant patents in the past. That is number one, right? And number two, if you are already developing some technology, you can look at the existing patents, the expired ones. After 20 years, the inventions or patents expire, right, after 20 years. So look at the expired ones. That is something people generally don't do. Look at the expired patents, and you can use anything in those patents for your business. Okay, let me tell you an example. There are a lot of pharmaceutical companies in India. It's all right to say the name of the country. They are doing this very well. Those pharmaceutical companies in India, they keep an eye on the drugs. Okay, drugs like atorvastatin or aspirin or Panadol or whatever, right? The drugs is a big market, and they keep an eye on the drugs that are expiring the next year, the following year, next month, and so on. And after expiry, they build it in India. They have back factories and all that for developing drugs, manufacturing, and they sell it to the market. So they are the probably third generic drug manufacturer in the world, and they are making huge amount of money out of them. So their usage of patent is completely different. They use the patents and expired patents for business. All right. So keep that also in mind. You can do that as well. Then the other thing I want to mention is that when you develop your own business, you have to handle so many things: investment, talking to your team members, legal matters, tech development, and now patents also get in the way. And easily you will be swamped, overwhelmed, right, with all of these works if you want to do it alone, right? So never try that. Make sure that we are telling this over and over again. You need to talk to people, get people on board, and in the process, probably you have to give some share to them. That's all right. Share your capital, share your intellectual property, share your assets with others. That's all right. Every entrepreneur, right, does that. Invite people, good people, talented people who can develop your company, right? And in return, you give them something, right? And when the company develops, right, everybody is benefited, including you. So you will be the major shareholder, right? You will be the most benefited person, but others also get benefit. So without the benefit, others will not join you, and you won't be able to stand up on your feet as an entrepreneur. Please understand that. Okay. All right. With that, I want to conclude today's session. It went nearly 2 hours. And thank you very much for being patient and being engaged. We really appreciate it. And we hope we can continue this momentum, courage, focus towards the end of the program. Okay. With that, let's conclude the session. And I'll see you next Saturday, 7 p.m. Thank you very much and good night.